A DUI arrest is not a conviction. Even after you have been arrested for DUI, there are still several ways you can avoid a criminal conviction and the severe and long-lasting consequences that result from a DUI conviction. Florida law gives defendants powerful legal tools to challenge, reduce, or completely dismiss a DUI charge. If you know your rights and act fast, the outcome can be very different. Let us break it down. The reality of DUI cases in Florida. A DUI arrest in Florida does not automatically mean a DUI conviction. Arrest and conviction are two completely different things. An arrest means law enforcement believed they had probable cause to believe you had committed a criminal act, such as operating your vehicle while impaired. Law enforcement officers cannot convict you of the charge they are arresting you for. A conviction requires the state attorney's office to prove beyond a reasonable doubt that you were driving or in actual physical control of a vehicle while impaired. Beyond a reasonable doubt is a much higher legal standard than the probable cause that allowed law enforcement to arrest you. The increased burden of proof necessary for a conviction allows experienced defense attorneys to successfully challenge the alleged evidence against you every single day in Florida courtrooms. Our DUI and criminal defense attorneys have the experience and expertise necessary to aggressively and skillfully defend the accusations against you. Under Florida Statute 316.193, the prosecution must prove specific elements of the offense. If any element cannot be proven, or if the evidence was obtained unlawfully, the entire case can fall apart. Here is exactly how a DUI charge can be dismissed in Florida, step by step. Ground 1. Unlawful traffic stop. The entire DUI case begins with a traffic stop. Under the Fourth Amendment of the United States Constitution and Florida case law, a law enforcement officer must have reasonable suspicion of a traffic violation or criminal activity before pulling you over. If the stop was not legally justified, everything that followed, the field sobriety tests, the breathalyzer, the arrest, may be thrown out entirely. This is called a motion to suppress. Your attorney files this motion arguing that the stop was unconstitutional. If the judge agrees, the evidence gathered during that stop becomes inadmissible. Without that evidence, the prosecution typically has no case and the charge is dismissed. Florida courts have dismissed DUI cases on this ground repeatedly, which is why the circumstances of your traffic stop must be reviewed immediately by a defense attorney. Ground 2. Improper field sobriety test administration. Field sobriety tests in Florida must be administered according to strict standards set by the National Highway Traffic Safety Administration, commonly known as NHTSA. These standards govern exactly how the walk-and-turn test, one-leg stand, and horizontal gaze nystagmus test must be conducted and explained to the suspect. If the officer failed to give proper instructions, conducted the test on an uneven surface, did not account for your footwear, age, weight, or medical conditions, or scored the results incorrectly, those test results can be challenged. Medical conditions such as inner ear disorders, back problems, knee injuries, or neurological conditions can all cause a person to fail field sobriety tests without any alcohol impairment being present. A skilled attorney will obtain the officer's training records and body camera footage to expose any procedural errors. Ground 3. Breathalyzer errors and machine reliability. Florida uses the Intoxication 8000 as its approved breath testing device. While law enforcement presents breathalyzer results as hard scientific fact, these machines are far from perfect. Florida has a long and documented history of Intoxication 8000 problems, including software issues, calibration failures, and improper maintenance. Under Florida Administrative Code Rule 11D8, breath testing instruments must be regularly inspected, properly maintained, and operated only by certified operators following specific procedures. If the machine was not properly calibrated, if the required observation period before the test was not followed, if the officer was not properly certified, or if the machine's maintenance records show prior issues, the breath test result can be challenged or excluded entirely. Without a reliable breath test result, the prosecution loses its most powerful piece of evidence. Florida courts have suppressed breathalyzer results for these exact reasons, and when that happens, charges are frequently reduced or dismissed outright. Ground 4. Lack of actual physical control. Florida law does not require you to be actively driving to be charged with DUI. However, the concept of actual physical control has specific legal boundaries. Florida courts have examined cases where defendants were sleeping in parked cars, sitting in vehicles that were not running, or in situations where driving was clearly not imminent. Florida case law, including the landmark decision in Depth of Highway Safety v. has shaped how courts interpret actual physical control. If your attorney can demonstrate that you were not in actual physical control of the vehicle as defined by Florida law, this element of the offense fails and the charge cannot stand. This is a highly fact-specific argument that requires an attorney who knows how Florida courts have ruled on similar situations. Ground 5. Rising blood alcohol defense. This is a defense that many people have never heard of, but it is scientifically valid and legally recognized in Florida. Alcohol does not reach its peak concentration in your bloodstream the moment you take a drink. It rises over time, typically peaking between 30 minutes and 2 hours after consumption. If you had your last drink shortly before driving and your breathalyzer test was administered 45 minutes to an hour after your arrest, your BAC at the time of driving may have actually been below 0.08. The test result reflects where your BAC was at the time of testing, not at the time of driving. An expert witness in toxicology can testify to this rising BAC defense, creating reasonable doubt about whether you were actually over the legal limit while behind the wheel. Ground 6. Violation of Florida's implied consent warnings. Under Florida Statute 316.1932, before administering a breath test, the officer is legally required to read you the implied consent warning and explain the consequences of refusal. This warning must be given properly and completely. If the officer failed to provide the required implied consent warning, or gave it in a way that was misleading or incomplete, the breath test result may be suppressed. This procedural requirement exists to protect your rights, and Florida courts take it seriously. Any deviation from the required implied consent procedure gives your defense attorney grounds to challenge the admissibility of the breath test results. Ground 7. Insufficient evidence of impairment. Even if the traffic stop was lawful and a breathalyzer was administered, the prosecution still needs sufficient evidence to prove impairment beyond a reasonable doubt. Officer observations such as slurred speech, bloodshot eyes, the smell of alcohol, and poor driving behavior are all subjective. These observations can be challenged through cross-examination, body camera footage review, witness testimony, and expert analysis. If the totality of evidence simply does not rise to the level of proving impairment beyond a reasonable doubt, your attorney can argue for dismissal or file a motion for judgment of acquittal at trial. Florida juries have returned not guilty verdicts in DUI cases where the evidence of actual impairment was weak or inconsistent. The role of pretrial diversion programs. Beyond outright dismissal, Florida offers first-time DUI offenders in many counties the opportunity to enter a pretrial diversion program. Counties including Miami-Dade, Broward, Palm Beach, and others have established DUI diversion programs where completing required conditions, such as DUI school, community service, and a victim impact panel, can result in the charges being dropped entirely. Successfully completing a diversion program may also make you eligible to have your arrest record sealed, protecting your future employment, housing, and professional licensing opportunities. Not everyone qualifies, and each county has different eligibility requirements, which is another reason why having an attorney who knows your specific county's program is essential. What you must do right now. If you have been arrested for DUI in Florida, time is your most critical resource. Remember the 10-day window to request a formal review hearing with the Florida Department of Highway Safety and Motor Vehicles before your license is automatically suspended. Do not post about your arrest on social media. Do not speak to law enforcement without an attorney. Write down every detail you can remember about the stop and arrest while your memory is fresh. Most importantly, contact a Florida DUI defense attorney immediately. The earlier an attorney reviews your case, the more options you have. If you are facing a DUI charge anywhere in Florida or Nevada, visit yndzlaw.com right now. The attorneys at Y&Z Law understand Florida DUI law and will examine every angle of your case to protect your rights, your license, and your future. The link is in the description. Do not wait, because in DUI cases, every single day matters. Subscribe now for more real Florida legal guidance. Knowledge is your best defense.